Hello everyone, welcome back to Courts Today by Live Law, your one-step destination for the latest and fastest legal updates. I'm your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Starting with an update on Manish Sisodia's bail plea. The Supreme Court has today reserved verdict on the petitions filed by former Delhi Deputy Chief Minister Manish Sisodia seeking bail in the liquor policy case. You are aware that he has moved the Supreme Court, assailing the Delhi High Court order of 21st May, whereby his second bail plea was rejected. He is seeking bail in the cases filed by the CBI and ED under Prevention of Corruption Act and Prevention of Money Laundering Act, respectively, in relation to the alleged liquor policy scam. A bench of Justices B.R. Gavai and K.V. Vishwanathan heard the contentions by Senior Advocate Dr. Abhishek Manu Singhvi for Sisodia and Additional Solicitor General S.V. Raju for the respondent authorities. The ASG argued that Manish Sisodia's plea for trial delay was caused by his own unnecessary applications instead of seeking discharge. He claimed that Sisodia delayed framing of charges and warned that releasing him could lead to evidence tampering and witness influence. These submissions were vehemently objected to by Senior Advocate Singhvi, who claimed that most of Sisodia's applications were allowed by the trial court. The senior counsel further pleaded that the ground of tampering was being taken for the first time and was intended to prejudice the court against Sisodia's interim release. During the hearing, let me tell you, the bench flagged an apparent inconsistency between ED's stances. As on one hand, it claimed that the trial could have commenced had Sisodia not delayed it by filing unwarranted applications, but on the other hand, it sought time on 4th June to collate data and file a final charge sheet. The judgment has now been reserved. Stay tuned with us for the verdict. A petition has been filed in the Supreme Court challenging the Bombay High Court's judgment upholding the ban imposed in a private college in Mumbai on the wearing of hijab, niqab, burqa, stole, cap, etc. by students on campus. It was on 26th June that Bombay High Court dismissed the petitions filed by 9 female students challenging the dress code prescribed by the authorities of N.G. Acharya and D.K. Marathe College. The students contended that the dress code was arbitrary and discriminatory, infringing upon their right to choose the attire, their right to privacy, right to expression under Article 19(1)A, and their right to freedom of religion. But the High Court referred to the full bench decision of the Karnataka High Court in Resham versus State of Karnataka, which upheld a government order prescribing a dress code excluding hijabs. When the petition was mentioned today for urgent listing, CJI D.Y. Chandrachud said that he had already assigned a bench for the matter and that it would be listed soon in the coming days. I must tell you that the challenge to Karnataka High Court's judgment is also pending before the Supreme Court after a division bench delivered a split verdict in October 2022. Coming now to the Patanjali advertisements case, which was listed today before the Supreme Court bench of Justices Hima Kohli and Sandeep Mehta. You are aware that the Supreme Court has criticized the president of the Indian Medical Association for his contemptuous remarks against the court in an interview. Today, the bench expressed displeasure with the nature of apology tendered by the president. Commenting that Dr. Ashokan was inviting more trouble for himself, the bench adjourned the matter to 27th August on a submission by Senior Advocate P.S. Patwalia that Dr. Ashokan would take appropriate steps to purge himself of the contempt. The bench remarked that the IMA president cannot wash his hands off by sending an apology to the Press Trust of India, and that the apology has to be published in all newspapers which carried his interview. Also, it has to be done using Dr. Ashokan's own funds and not the funds of IMA. The observations came in response to Patwalia's explanation that the IMA president's comments were a response to 2 questions asked during the interview with PTI, which lasted for about 1.5 hours, and the IMA was not publishing advertisements. The Supreme Court has today dismissed a PIL seeking publication of the segregated date of clinical trial phase 3 of the vaccine Rotavac administered to infants to protect against diarrhea. The petition was filed in 2016 seeking publication of the data of the clinical trial of the vaccine against rotavirus, conducted between the years 2011 and 2013. Advocate Prashant Bhushan, appearing for the petitioner, asked that since the clinical trial data was already collected, what was the impediment in releasing it? He submitted that the trial data has to be disclosed to the general public as per Helsinki Guidelines 2015, Bioethics Committee and ICMR Guidelines 2017. Senior advocate Devdutt Kamath, appearing for the Christian Medical College Vellore, where the clinical trial was done, opposed the petition, saying that it was based on hearsay newspaper reports without proper research. He cited the Supreme Court's judgment in Jacob Pulial case, which turned down the plea to publish the clinical trial data regarding COVID-19 vaccines. The bench, comprising Justices B.R. Gawai and K.V. Vishwanathan, observed that the court could not sit in appeal over the decision taken by the expert committee of the National Technical Advisory Group on Immunization and thus dismissed the petition. In the next update, the state of Punjab has filed an application seeking urgent release of funds from the union under the alleged dues of market fees and rural development fees. The Punjab government filed a lawsuit in the Supreme Court last year, accusing the Union of India of refusing to reimburse the statutory charges known as rural development fee. According to the lawsuit, these charges are imposed by the state of Punjab to cover costs related to acquisition and procurement of food grains. This procurement is carried out by Punjab on behalf of Union of India to ensure food security across India. The Punjab government claims that Union's refusal to reimburse these charges is unjustified. Now, the state has filed an interlocutory application in the original suit filed last year. Punjab Additional Advocate General Shahadan Farasat requested the CJI for an early listing of the interim application seeking release of funds from the union, to which the court agreed. The Chhattisgarh High Court has emphasized that corporal punishment is not a part of education, is incompatible with a child's dignity and violates the right to life and liberty under Article 21 of the Constitution. The case here involved a teacher, Sister Mercy, from Surguja district. She has been charged under Section 305 of IPC for allegedly abetting the suicide of a Class 6 student. The student hanged herself in February, leaving a suicide note accusing the teacher of harassment after the teacher confiscated her identity card in the school toilet. The student's fear of facing her parents about the incident allegedly led to her suicide. The teacher filed a petition to quash the FIR against her. In her defense, she argued that she was merely performing her duties and maintaining discipline. However, the court maintained that at the stage of considering a quashing plea, only the prosecution's material could be considered and not the defense's evidence. The court has dismissed the petition to quash the FIR related to the abetment. A bench comprising Chief Justice Ramesh Sinha and Justice Ravindra Kumar Agarwal noted that subjecting children to physical violence in the name of discipline or education is cruel and dehumanizing. And lastly, the Apex Court today admitted the state of West Bengal's appeal against Calcutta High Court's order which directed CBI to probe into the incidents of alleged violence following the 2021 State Assembly polls. With regard to the 2021 State Assembly elections in West Bengal, marred by allegations of post-poll violence and widespread unrest, and amidst reports of displaced individuals being denied the right to return to their homes, the Calcutta High Court had ordered formation of a committee to address the situation. Further, a National Human Rights Commission committee submitted a report accusing the ruling party of orchestrating a law of ruler regime rather than upholding the rule of law. The NHRC report recommended that serious offences including murder and rape be investigated by the CBI and tried outside the state to ensure impartiality. Following this, the High Court in August 2021 handed over the investigation to CBI. However, the West Bengal government has consistently questioned the NHRC report, expressing concerns about its impartiality and validity. The bench of Justices M.M. Sundaresh and Arvind Kumar of the Supreme Court have granted leave to appeal in the special leave petition filed by the state and sought CBI's response to this plea. The matter will next be listed on 20th November. Stay tuned. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.